return to the courthouse. Anything the state wants to put on the record regarding the view?
No, Judge.
For the defense?
Yes, Judge, we'll move for mistrial at this time.
Yes, sir. You can proceed.
The evidence, and to make clear, we've objected to this view from the beginning on several grounds. One of the primary concerns that we've had is that this procedure, this view, invites the jurors to substitute their view, substitute what perhaps they could see or not see for what Ross Harris could see or could not see on June the 18th. Now, the evidence in the case that we've had regarding Ross's return to the car at lunch when we put the light bulbs in the car, we've seen several angles of the video surveillance footage from the Home Depot parking lot. In that video, what we see, of course, is Ross getting out of his friend's car, approaching his car, opening the door. One arm goes in, he closes the door. We've looked at it lots of times. Our position is it's very clear that his head remains above the roof line. It's very clear he never gets inside the car. It's very clear he never leans in the car. It's very clear he never looks back toward the back of the car where the car seat would be. But we've also had testimony. Specifically, I want to call the court's attention to the testimony of two non-law enforcement, non-police witnesses, and that was Walter Pineda, who's the video enhancer, and Mr. Sanders, who was the security man for Home Depot. Both of these gentlemen reviewed the same materials, and what their testimony was, yes, it appears that his head remained above the roof line the entire time. He did not lean in the car, get in the car, or look back in the car. Detective Stoddard himself testified before Magistrate Strauss to that very specific fact, telling Judge Strauss that Ross's head remained above the roof line. He testified to the same thing before this jury. So what we've actually got, the objective evidence that we've got, that the jury has heard, is that Ross, his head was above the roof. He never leaned into the car. His head never came into the car, and he never looked back. But now we've done this procedure that the defense has objected to all along. And I want to point out that we've got jurors of all different heights on this jury. I'm 5'5", but we've got a couple of jurors that are even shorter than I am. And what we just observed when they did the jury view was several of the jurors came into the door frame, and they were clearly substantially shorter than Ross Harris. Their view, merely standing in the frame, would have been totally and completely different from the objective evidence that is in this case. We also saw a number of these jurors not only stand in the frame, but lean their head inside. Oh, they didn't get in the car, they didn't get in the seat, but several of them we observed they leaned their head inside. There is no evidence in this case that that ever happened. None. It's clear from the video, it's clear from the testimony of the witnesses. We also saw several of the jurors, when they came up to the door frame and they leaned in toward the frame, or even through the threshold, turn and look in the back. There is no evidence in the case that happened. In fact, all of the evidence is absolutely contrary to what we saw the jurors doing. The viewing that we just had is essentially tantamount to a recreation. It's a recreation where the jurors put themselves in that place and walk around from their vantage point, from their viewpoint, from their height. And they could do it in a way that is inconsistent with the evidence. Not head above the roof line, one arm in, the right arm in, closing the door and walking away in 5 seconds. No. They did it in a way that suited them, which was at their height, from their viewpoint, what their eyes could see, leaning into the car and looking back. That is absolutely inconsistent with the evidence. It's absolutely inconsistent with what Mr. Harris did and was able to see and not see from the objective evidence of the video and the testimony that has come before this jury. So what we're left with is exactly what I warned the court about months ago when this first came up, which is we're in a situation now where the jurors have been given free rein to substitute their vantage point, their viewpoint for the evidence, for what Mr. Harris could or could not see from his height, from his viewpoint in that 4 or 5 seconds that we saw on the video. I want to also point out that because this was tantamount to a recreation, Judge, it was not under the same conditions. What we saw in the video in the parking lot was this was in the midday hour. It was in sunshine. Well, the car, as it was placed out in the parking lot this morning, was under a canopy of trees at 9-something in the morning. Well, why is that important? That's important because it changes some very specific variables. It changes the light. It changes the way the light reflects off the windows. When you have tinted windows, they appear darker depending on what the light is. And what I observed of the recreation that just occurred, we had several jurors who actually went about 12 or 15 feet in front of the car, walked toward the car, and around to the front door. Well, they're doing that, obviously, to see what they can see, walking directly toward the car through the windshield or through the windows. And again, it allows them to substitute what they think they could see or not see for what Ross Harris could see or not see under very different lighting conditions. And we've heard testimony about how lighting really makes a difference. And if the court will remember, we had two images just from different camera angles, one from the left camera, one from the center camera. We're on the car, the whole windshield was whited out. Why? Because that was a reflection of the sun. But when we got to the left-hand camera and showed that view, the windshield was black. Why? Because the way the light reflected from that angle was very different. And so I think that we've allowed a demonstration, as in on June the 18th, 2014. And here's the real kicker. We have got a mountain of evidence in this case about what the conditions were exactly on that day. We've got multiple angles from videotapes, we've got pictures, we've got all kind of testimony. We know what it was like then. The jury can know what it was like then from the evidence that is in the case. But now, with this demonstration, they can substitute what they saw from their height, from their vantage point, from their leaning in, from their looking, under completely different lighting conditions. I think it's completely messed the trial up. I think he is absolutely going to be denied a fair trial. I don't think it can be undone. I don't think that, I'm asking for a mistrial.
Thank you. Yes, sir.
Thank you, Your Honor. It's quite the production, much like the defense of the crime scene when we started. So I would just put that in context with that. Judge, you granted this view months ago, and as we sat here yesterday and the day before talking about this, it was discussed where it would be. It was discussed when it would be. And the defense now wants to sit on their hands and say, we're not going to give input when Your Honor says we're going to do it at 8 a.m., and to now jump up and down and say it should have been done differently when they posited no suggestions at that moment, to start with. Another observation I would say, just for the record, is I actually think it made the windows look more tinted out there in the morning hours. I think what is important here, that I think the defense is missing the absolute mark on, is that they want to view a piece of evidence. There's not going to be any instruction or anything that this was some recreation of the actual acts. What the defense is also missing is this was something that occurred the entire day. The jury was absolutely allowed to go in and look at this piece of evidence, to look inside, to see what the defendant saw that morning while he's driving with the child, to see where the car seat was actually situated in a real environment, to see where the driver's seat is located in a real environment, to see where the defendant was sitting for those 30 seconds while he's messing around in his car that morning while the child is sitting there right beside him. They're allowed to see how it looked when he came back. He comes back to the car that afternoon. We forget about that. That's not mentioned. He gets in and sits down right beside his dead child and drives for minutes. This wasn't just, we're looking at this evidence to see what happened at lunch. This is the murder weapon for this entire case. The jury has the evidence about how tall he was. They've got the videos. They were not instructed that they're to substitute their view for his. What they're doing is examining a vital piece of evidence in this case. Judge, I think it was handled completely appropriately and professionally, and now the defense is trying to engineer error by, nana boo-boo, we don't want to participate in giving any suggestions, but now that it's happened, we're going to ask for a mistrial. So we would absolutely object and ask Your Honor to deny the motion.
Respectfully, I'm not certain that he addressed a single word that I said. This was a disaster. It was an absolute disaster, Judge. There's no way around it. And he has been absolutely denied a fair trial after that little recreation that occurred outside. There is no other option but a mistrial at this point.
The vehicle is evidence in the case. It was tendered and it was admitted into evidence in this case. The jury has a right to look at every piece of evidence. Most generally that occurs in their jury room, in their deliberations. The vehicle is too large to bring into their jury room. This is the only opportunity they have to look at it. An argument can be made that the limiting manner in which the view was established and set up was too restrictive, not too generous. An argument can be made that as an exhibit in the case, the jurors should have had a right to open and close the doors themselves, to get in and out of the vehicle themselves, to go into the back, the rear seats of that vehicle themselves, to open up and close the rear hatch of the vehicle. An argument can be made that it was restrictive to them. It is an exhibit in the case, and they have a right to evaluate it along with all the other evidence of the case. There was not a recreation. It was a very structured and limited opportunity for the jurors to inspect an item of evidence relevant to their task and their job as a jury to evaluate the evidence, apply the law, and render a verdict that speaks the truth to this case. And therefore, I deny the defendant's motion for mistrial. All right. See what time it is. Have you got another witness ready to go?
Yes, Judge.
I'm gonna take about 3 minutes. Y'all can have 3 minutes and they'll be ready to go.
Thank
Make
you.
sure the jury's ready to go.
Yes, ma'am.